Very warm welcome, everybody, to our very first DECA branded webinar, or as one member of Chambers has taken to calling it a decanar. We're delighted to share our new Chambers with you and to hopefully start meeting some new faces. I know that some of you know me because I can see on the attendee list who is here, but for those that don't, I'm Ella Davis. I'm joined today by Anirudh and John, and we're going to be talking about consent and clinical negligence claims. Anirudh is going to be taking breach, John causation, and then in the event that somehow they have any time left in an hour after covering those meaty topics, I'm going to be sharing some practical tips on both bringing and defending claims where consent is an issue. You can share your questions with us while we're talking. We ask, please, that you do that in the Q&A box that you will find at the bottom of your screen. Please don't raise your hand because I don't really know how to respond to you if you do that. You're welcome to chat in the chat box to us or each other, but if you have a question that you would like us to pay attention to and answer, can I ask you to put that in the Q&A box, please, because it is too much for this bear of little brain to deal with the chat, the Q&A, and managing the slides all at once. So I will only be looking at the Q&A for questions. But without further ado, I think that covers all of the housekeeping. I will mute myself and hand over to Anirudh.
Thank you, Ella. What better topic to commence this webinar series than informed consent? This area was revolutionized 7 years ago by the landmark case of Montgomery and Lanarkshire, and is set once again to be the subject of Supreme Court jurisprudence in McCulloch and Fourth Health Board. Next slide, please. The starting point for any alleged failure to provide informed consent is Montgomery and Lanarkshire. It's a case that I'm sure that you're all familiar with, but it's worth a reminder of the facts of the case. It's a Scottish case where the pursuer was pregnant, diabetic, and of a small stature. Her consultant obstetrician did not inform her that the risk of shoulder dystocia occurring during a vaginal birth was 9 to 10%. Indeed, the consultant considered that these risks were low, but that if she told all diabetic patients about them, they would opt for an elective cesarean operation, which was not in their interest. During the course of the delivery, shoulder dystocia occurred, and the baby suffered both a brachial plexus injury and brain damage. Now, prior to the Supreme Court's judgment, the old law on informed consent focused on whether the admission was accepted as proper by a reasonable body of clinical opinion. The pursuer's claim accordingly failed in both the outer and inner courts of session. Next slides, please. In the Supreme Court, Lords Kerr and Reed recognised that times had changed. Medical professionals were more likely to disclose information and reach consensual decisions with patients about treatment options. Patients were viewed as individuals holding rights rather than as mere passive recipients of healthcare. Indeed, the passing of the Human Rights Act had made the courts conscious of the extent to which the common law ought to reflect fundamental values, including the value of self-determination. A new test was formulated. The nature of the duty, and it's worth a reminder, is that it's a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. Next slide, please. The Supreme Court went further and defined a material risk as one where a reasonable patient in the person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. So pausing there, the focus of materiality is on a patient-centered approach rather than on a clinician-centered approach. Further guidance was given. The first, and one point that is important to recognise, is that assessment cannot be reduced merely to percentages. Next slide, please. One should take a holistic approach to assessing whether the risk is material, and that includes identifying the nature of the risk, the effect of its occurrence on the life of the patient, the importance of the patient to the benefits sought to be achieved by the treatment, and the alternatives available and the risks involved in those alternatives. Next slide, please. There are two narrow exceptions to this rule. First, in circumstances of necessity, such as where a patient is unconscious or unable to make a decision and treatment is required urgently. Second, where the information would be harmful to the patient and could cause psychological damage. It is worth noting that the Supreme Court in Montgomery stated that these exceptions should not be abused. They are not intended to subvert the overriding principle that the patient ought to be made aware of any material risks. Next slide, please. So, how does this principle apply in practice? Well, a good starting point is the case of Montgomery itself. The Supreme Court unanimously allowed the pursuer's appeal. The pursuer should have been informed of the risk of shoulder dystocia if she were to proceed to a vaginal delivery, and there should have been a discussion about the alternative of a caesarean section. Next slide, please. Now, Montgomery substantially reinterpreted the law of informed consent. However, it is not the last word on the subject. 7 years on, new controversies have arisen over informed consent, and there are three which I will focus on today. Namely, the role of the old Bolam test in identifying the preliminary risks. Second, the application of Montgomery where the claimant lacks capacity. And third, the interpretation of reasonable alternatives in the Montgomery text. Next slide, please. Now, when considering the identification of material risks, the key case is Deuce and Worcestershire Acute Hospitals NHS Trust. The claimant had a history of painful and heavy periods. She sought medical advice, and a total abdominal hysterectomy and bilateral salpingo-oophorectomy was recommended to relieve her symptoms. The registrar informed the claimant that there was a risk of post-operative pain associated with surgery. However, no mention was made of chronic post-surgical pain. Now, the surgery was performed non-negligently, but after the surgery, the claimant began to develop chronic post-surgical pain. Next slide, please. So it was alleged in this case that there was a failure to warn of neuropathic pain and the chronic pain. The first instance judge, His Honour Judge Worcester, dismissed the claim. On breach, he held that in 2008, which is when the alleged tort occurred, there was insufficient understanding among gynecologists as to the risk of chronic pain prior to justify the imposition of a duty. The case was appealed to the Court of Appeal on the basis that, by relying on expert evidence, the judge had fallen back on Bolam rather than Montgomery. Nevertheless, the Court of Appeal dismissed the appeal. In the lead judgment, Lord Justice Hamberlin identified that ascertaining whether a risk should have been told to the patient was a bipartite test. Next slide, please. So this is really important. First, one must identify, when considering the identification of a material risk, the first point is to identify what risks are associated with the operation and should have been known by the medical professional. And this is a matter falling within the expertise of medical professionals and is governed by Bolam. Now, whether the patient should have been told of the risks is by reference to whether they were material. Now, this point, it's a matter that's not purely governed by expert evidence, and it's a matter for the court to decide in accordance with the principles that I set out earlier. Therefore, the critical point of this case is that before you even deal with the assessment of materiality, the risk must have been known to the medical professional in question at the time. This is a matter governed by clinical professions. So in Deuce, it was common ground between both experts that chronic post-surgical pain was not common knowledge among gynecologists in 2008. Therefore, the claimant's claim fell at the first hurdle, the first step of the bipartite test, and no analysis of materiality was required. Next slide, please. Now, it has long been recognised that one of the few exceptions to informed consent is where the patient lacks mental capacity. And there are two judgments of the Court of Protection which are of note in this regard. The first is NHS Trust and JP. Now, JP, the mother, suffered from microcephaly and associated behavioural issues to the point where she had not engaged with clinical professionals involved in the pregnancy. Now, she had expressed a wish to have a natural birth. The medical professionals were confident that she did not understand how difficult or dangerous a home birth would be, and they felt that the consequences of her refusal would have endangered both her and her baby. Now, of course, the Trust was unable to enforce treatment against the mother's wishes and applied to the Court of Protection for an order that JP would be transferred to hospital against her wishes and using reasonable force if necessary, and that on arrival, that she would be drugged or sedated without her consent, her baby delivered, and passed into the care of the local authority. Next slide, please. Mr. Justice Williams, sitting in the Court of Protection, concluded that JP did lack capacity and the application was successful. A natural delivery would be profoundly distressing and extremely risky for her life. Therefore, it was in her best interests for JP to undergo a planned caesarean option in accordance with the Trust's proposed plan. He accepted that there would be an element of deceit, but that was justified because it was in their best interests and it was compliant with Article 8 of the Human Rights Act, of the Human Rights Convention. Now, it might interest you to know this, but after the judgment was handed down, JP actually went into labour spontaneously the day after the hearing and delivered a healthy baby naturally at hospital with no restraint or sedation. Now, this does not, of course, mean that the application was ill-founded or that the judge was wrong, but it is a reminder of the gap between probabilities and actuality. Next slide, please. The next case is an NHS Foundation Trust and an expectant mother. In this case, the mother had been diagnosed with agoraphobia, fear of open spaces. The consensus view of the psychiatrists involved was that this caused her to be unable to make a decision about whether to have her baby at home or in hospital. An application to the Court of Protection was made, and Mr. Justice Hallman accepted that the mother lacked capacity to make decisions about the location of her birth. Her agoraphobia was so overwhelming that it exerted a significant effect on her ability to weigh matters in the balance. Accordingly, he concluded that it was in her best interests for the health authority to use a reasonable amount of force to transport her to the hospital. Again, interestingly, after judgment was handed down, the mother went into labour at home and gave birth in hospital where no restraint was required. Next slide, please. In Montgomery, the Supreme Court made it clear that part of the doctor's duty of disclosure extends to disclosing the existence of any reasonable alternative or variant treatments and the risks involved in those alternatives. However, they did not elaborate on what is meant by a reasonable alternative. In Bailey and George Eliot Hospital, Honourable Judge Worcester, sitting as a Deputy High Court judge, considered the test to be applied as to what was a reasonable alternative. In this case, the claimant claimed that her treating clinician should have advised her of all treatment options, including those available to her outside of the UK. Specifically, it was alleged that that there was a failure to advise that her deep vein thrombosis could have been treated by an iliofemoral venous stent. Next slide, please. His Honour dismissed the claim, and in doing so set out the following guidance. Of course, the reasonable treatment ought to depend on the patient, the treatment on prognosis. But importantly, it must be within the knowledge of a reasonably competent clinician at the and satisfy Bolan. Indeed, it must be an appropriate treatment and not one that is theoretically possible. And ultimately, there was not enough known about the iliofemoral venous stent for it to be considered negligent by Montgomery standards. Now, similar approaches have been followed again in England in the case of Mallock and St George's University Hospital NHS Trust, and Scotland. Now, in Scotland, the issue was recently considered in the case of McCulloch and Forth Valley Health Board. I'm probably butchering McCulloch. Given that this case will be of considerable importance, I will set out the facts in full. Next slide, please. This is a very sad case. The claimant suffered with symptoms including nausea and chest pain. He was admitted to hospital and underwent 3 echocardiograms. The clinician was approached for advice regarding the interpretation of the 3rd echocardiogram, and it was satisfied that it did not show any significant features indicative of life-threatening conditions. The claimant died the next day as a result of cardiac arrest. A claim was brought against the health board, and one of the grounds was that the clinician had failed to prescribe non-steroid anti-inflammatory drugs, or NSAIDs. Next slide, please. And it was argued that the claimant should have been made aware of NSAIDs as a reasonable treatment option. Now, both the outer and inner courts of session rejected the claimant's claim. Both courts held that the question of whether or not a possible alternative treatment is reasonable should be determined according to the principles of Hunter and Hanley, which is the Scottish equivalent of Bolan. But I can confirm that permission has been granted for this to be heard by the Supreme Court. The claimant seeks to argue that for a patient to make any informed decision, they need to be informed of all reasonable alternative treatments and not just the ones the doctor chooses to discuss with them. Essentially, they're seeking to reverse the current state of the law, and I'm happy to discuss my thoughts on the appealing questions later on. Now, that concludes the section on breach, but as you all know, it is insufficient to bring a claim purely on breach. I hand over to John to discuss causation issues in informed consent claims.
Hello, everybody. I hope you can hear me, and thank you very much for that first section. Yes, issues of causation and informed consent is complex and worthy of possibly a textbook, but we're going to try and do it in about 20 minutes in terms of where we are. The starting point really with Montgomery and causation is to look at it in the context of the Chester and Afshar authority and really ask ourselves the question whether those two cases can live together, and think about the fact that Montgomery is a case that is trying to move away from the paternalistic dynamic within a doctor-patient relationship on the issue of consent, and move it much more towards enabling patient autonomy. So it's the idea that it's for the patient to decide which, if any, of the forms of treatment that are available should be undergone, and consent must be obtained before treatment is undertaken. So where do we go with that shift from paternalism, medical paternalism, towards patient autonomy, when it comes to the issue of causation, i.e. what is the causative effect of any breach of duty to warn or establish consent? So we're going to look at that. Next slide, please. Thank you, Ella. So we're going to look at first principles, which Annie just touched on. But basically, if a patient suffers physical harm during medical treatment, when a risk materializes about which the doctor failed to warn the patient, there are 2 key issues to the claim. 1, was the doctor negligent in failing to warn about the particular risk? And 2, should that failure to warn be causative of the damage suffered? So we know Montgomery gives us a lot to think about in terms of section 1, but where do we go with section 2? So let's interrogate that question. Ella, next slide, please. Thank you. So we're going back 11 years back from Montgomery to Chester and Afshar. So this is about a failure to warn. So Mrs. Chester undergoes an operation performed without negligence by the surgeon but she does suffer nerve damage resulting in a cauda equina syndrome and a very serious and sad result of that operation. Now, she didn't really want to have surgery, but she's not presented with any options other than surgery by her doctor, and the risks explained in surgery were not adequately explained, and those are findings of fact from that case. Next slide, please. So this is a risk so the complication that eventuates in Chester was a risk of about 1 to 2%. So the facts of that claim are the doctor didn't say to her, by the way, you should be aware there is a risk of 1 to 2% of developing this this complication. So that is the breach of duty. What is the causative effect of Mrs. Chester not being made aware of that risk? Well, again, these are all very fact-sensitive findings, but on the facts of Chester, she may actually have still had the procedure, but not today, not on that particular time. She would have taken some more time, some time to reflect, some time to get a second opinion before going ahead. So the operation would have been delayed. And that is enough in Chester for causation to be made out. So how do we square that with Montgomery? Next slide, please, Ellen. So causation is notoriously unusual in Chester. So the House of Lords were not unanimous. In fact, there were powerful dissenting judgments in Chester from Lord Bingham and Lord Hoffman. Lord Steyn, though, said we can depart from established legal positions on causation in order to vindicate the patient's right of autonomy and dignity. So it's accepted, I think, in that judgment that actually normal causation isn't established. And if you're not sure what I mean by that, what I mean by that is she would have had the operation that caused her complications in any event. So the evidence is, if she'd had the proper advice and the proper duty to warn had been met, she still would have had the operation, and therefore the 1 to 2% risk would still have been there, and the injury could still have happened in exactly the same way. So that's the problematic aspect of causation. And in the dissent, Lord Hoffman says the purpose of a duty to warn someone against a risk involved is to give that person the opportunity to reduce that risk or to avoid that risk if that person is actually going to be unable or unwilling to take that opportunity, and then the risk eventuates, when then the failure to warn is not causative of the damage. It would have happened anyway. And that was the basis of the dissent in Chester. But the majority allow the claim to succeed, and it's interestingly all to do with vindicating autonomy and dignity, which is very much the sort of rationale of the Montgomery judgment. So my question at the bottom of the slide, does it sit happily with Montgomery's moving away from the inquiry into what a reasonable doctor would warn about, and instead moving the inquiry towards an emphasis on patient autonomy? Well, actually, yes, you think that actually Montgomery sits quite neatly with Chester in terms of the ratio and what the court's trying to do in terms of shifting to a patient's rights rather than a paternalistic view of a medical professional. Next slide, please, Ellen. But as I've talked about, Chester is a very difficult case on causation. So Hart and Honore, who've written leading academics on causation, they talk about the falling tree syndrome on causation. The falling tree syndrome is the idea, the concept of being in a motor car and driving at, say, 100 miles an hour through a country road, and as you go around the bend, a tree happens to break off from its branches and fall right on top of the bonnet of your car and cause you an injury. And the issue is, what is the connection between driving at 120 miles an hour, which then means that at a particular point of time and space, your car is where the tree in a freak accident lands and causes you injury. The breach of duty, the failure to take reasonable care, the recklessness of driving at 120 miles an hour means in some way that you are at a particular time and place. But is it causative of the fact that the tree hits you and causes your car to come off the road and causes you injury? What is the causative connection between those two things? They call that coincidence, a coincidence in time between two things. And you could say that in Chester and Afshire, that parallel to some extent stands with what happened to Miss Chester, because was it in fact coincidental to the defendant's failure to warn that Mrs. Chester suffered injury? She was ultimately willing to undergo the operation with the same risks on a different occasion. Or is it just straightforward but for factual causation, which is really the sort of, if you like, the Chester rationale, which is, well, if she had been warned, she wouldn't have gone ahead with the surgery then and there, and so the injury would have been avoided because it did in fact eventuate on that day. So you can see the issues with causation are complicated, and obviously there's a range of possible behaviours that might follow not being, if you haven't been warned of a risk, there's a range of possible behaviours that could follow the eventuality where you were warned, which is always to some extent speculative in terms of what you would have done. But for example, you might have, as Mrs. Chester did, have wanted a second opinion or wanted time to reflect, or you might have delayed because you wanted to get a more specialist surgeon to do the work, which could result perhaps in decreasing the risk of what was going to happen. Or you might have, of course, wanted to delay it for a practical reason. Maybe you didn't want to be facing that kind of risk at that particular moment in your life. Maybe there was a very important event around the corner, like your partner having a child, or you being close to retirement, or these kinds of issues. Or, of course, you might have just not had the surgery at all, in which case causation is simpler. Next slide, please. So, what's the point of the duty in Montgomery in terms of its relationship with these issues of causation? Well, is it to enable the patient to choose whether or not to run those inherent risks of which they're being warned, and thereby to avoid the occurrence of the particular physical injury, the risk of which the patient is not prepared to accept? Is that the point? You've been warned, you know there's a risk, and therefore you want to avoid the risk. Is that the point of causation? Or is it in fact not that, which is what you might think it would be? Is it what Lord Kerr and Lord Reid say? The rationale of the duty is to enable patients of sound mind to make for themselves decisions intimately affecting their own lives and bodies. And Lady Hale talks about in the same judgment, autonomy is the freedom to decide what shall and shall not be done with their body. So I hope you can see where I'm going with this, and it's quite subtle, but Chester and Afshire and Montgomery seem to be much more interested in bodily autonomy of the patient rather than perhaps what we might think are much more straightforward red lines of causation, which is effectively needing to establish but for factual causation on a failure to warn leading to causing injury and loss. Next slide, please. Well, let's see how those issues have shaken down in judgments since Montgomery to do with the issue of causation. So we have Webster and Burton Hospital's NHS Foundation Trust in 2017. And here we had a consultant obstetrician who should have arranged further ultrasound scanning every 2 weeks for a pregnant woman. She had a fetus that was small for the gestational age, so it was a very small baby inside her, and there was therefore a need to be doing scans frequently to check everything was as it should be, and there was a breach of duty admitted. Now what happened was, very, very sadly, the baby was injured during birth, and she had a umbilical cord get tangled around the baby while in utero, and that caused, unfortunately, a brain injury. Next slide, please. So at first instance, the case it loses on causation. So the evidence is that if she had had these extra scans, ultrasound scans, then the trust would have been looking at the baby and the development more frequently. They would have discussed those issues with Mr. Butler, but it wouldn't have changed anything about the fact that they would have gone ahead with the birth in the way they did, and therefore the loss would always have been suffered in any event. Now that was appealed. That was appealed because of what we've been talking about, Montgomery. And in light of Montgomery, it was held that if the material risks had been explained to the mother, she would have opted for an earlier delivery, which would have avoided the baby's delivery in the circumstances that did transpire, and therefore the injury would never have happened. So but for causation was held out, and Montgomery actually assists with establishing causation in that case. The sort of footnote, though, to that case is that the duty to warn of the risks and the need to have scans was to do with the development of the baby as a baby, a fetus that was too small as against the background data that you would expect. That wasn't, however, that didn't mean that the baby was at risk of cord damage in utero. For any of you who work in that or in this area of law, who have partners who've had babies, you'll know sometimes babies move around, and there's a risk of cord damage when in utero, and it's not linked to the breach of duty. So there's an interesting causative point here, which is that the duty to warn of the risk and the duty to have the scans is actually not causatively linked to what in the event happens and what causes damage to this child. So there's a problem there with the nexus, but that is glossed in terms of applying Montgomery and getting the resultant causation that the court seeks. Next slide, please. So we come to Korea and University Hospital of North, Stafford NHS Trust, and that's the emphasising there that Chester is an exception. So it's our first sort of movement away from Chester, if you like, which you'll see developing, and it needs to be pleaded specifically, all of you practitioners out there, and you need to prove that if warned of the risk, you would have deferred the operation. So it's linked very much to findings of fact on what the patient would have done. Next slide, please. Now, Duce, we have already been heard of on breach of duty in some depth. And again, this further seeks to move us away from Chester and those sort of difficult points I've been referring us on. We see the court moving away. So Lord Justice Hamlin says that Chester doesn't mean that you don't have to get but for causation. So all those points I've been saying that really Chester was very problematic on causation. Hamlin says no, there's no problem there, nothing to see here, you need but for causation. And interestingly, in Duce, the argument that the claimant made was that Chester created a separate pathway to establish causation in consent cases. The claimant argued in Duce that as long as an injury is involved intimately with the duty to warn, and the injury was the product of the risk the patient should have been warned about, then causation is established. So it's exactly what I've been addressing you on in terms of what Chester would seem to show. But the Court of Appeal disagree with that, and they say you need but-for causation, and it's critical of Chester, the judgment there, particularly Mr. Justice Leggett says that he's unsure of the policy grounds that seem to play a large factor in Chester and in moving away from traditional causation principles. It emphasizes that it would only apply in exceptional circumstances, and again confirms for a consent case in future, the claimant's got to show that they would have deferred treatment or would have decided to have no treatment. So this lingering idea in Chester that actually you probably would have had the treatment, but maybe you would have taken a bit more time to think about it, that isn't going to cut the mustard, really, if you read Chester in light of Duce. And I think it's an attempt to really move away from some of the difficult implications of Chester on causation that I've been talking to you about. Next slide, please. Interestingly as well, I've been speaking to you about Chester being about autonomy, the dignity and autonomy of a patient being behind the policy reasons in Chester. In Montgomery, we talk about autonomy as key, and actually that led to Shaw and Kovach, where just a failure to obtain informed consent of a patient, could that actually just be a freestanding right to damages, a bit like general damages and personal injury and clinical negligence? You might think about, damages to feelings or pain, suffering, loss of immunity. Could you have the encroachment on someone's personal autonomy as a freestanding right to damages without causation beyond that? And the Court of Appeal said, no, absolutely not. Stop trying to widen the heads of loss and widen the tort of negligence just because we've been going on about this in several judgments, and they shut the door on that. Next slide, please. And so we come to Diamond and Royal Devon and Exeter NHS Foundation Trust. This is a case about an abdominal hernia being repaired using a surgical mesh in order to essentially sew up the hernia, and there's an issue having a baby in the future given this repair. Now, the claimant here was not advised that she could have had a suture repair, and that was a breach of duty. But the case loses on causation, because even if she had been given the information about the alternative of a suture repair, she would have anyway gone ahead and had the surgical mesh. So causation fails. The Court of Appeal repeat, there's no freestanding claim you can get simply from the breach of duty, i.e. the failure to obtain fully informed consent, i.e. the invasion of the right to personal autonomy. If the doctor makes a mistake here, you still need causation, and there's no causation in this case. Next slide, please. Or is there? No. It was appealed and said, well, she would have gone for a suture repair. What about that situation? And the Court of Appeal said, well, you've got to be rational. You've got to look at rationality. And the court said, having a suture repair, would have been a really silly, irrational thing to do. No one sensible would have gone for that, because a suture repair wasn't, as it probably sounds like, wasn't going to be strong enough. It was going to be liable to fail with a high recurrence of the risk of the hernia. So anybody sensible, given the option, would never have gone for that. Therefore, causation fails. Now that sits to me uneasily with Montgomery and with Montgomery and Chester, because the whole point of Montgomery is autonomy, and Chester talks about the fact, it actually quotes from the fact that we should allow someone to choose death over a blood transfusion if that is his informed wish, because we acknowledge his right to a life structured by his own values. So Chester actually explicitly looks at the idea of making it an irrational or perhaps not sensible decision and says that's sort of the whole point of autonomy. Whereas here we are in Diamond, and the court's being paternalistic. The court's saying that actually we think this is only a sensible person would do this, so we're going to discount the alternative treatment because you never choose it. So it's an interesting aspect of Diamond that that shows a paternalistic judiciary. Next slide, please. So in Kay and Homerton University, it's the same as well. It's a patient who's advised to have a labour at 37 weeks because the baby is concerningly not growing in the utero. She has an emergency cesarean, and in a very tragic case, she dies of postnatal sepsis. There was a breach because she wasn't advised that she would need she was at high risk of needing an emergency cesarean section, but the claim lost on causation. Again, the judge here finds even if she was given advice about the fact that she was at a higher risk of ultimately needing a C-section, she would have anyway gone for a vaginal birth. That would have been her choice, even though the widower said actually she wouldn't have done. My view is that she would have gone for the C-section. The judge said no, paternalistic judiciary, no, this is what would have happened, and he fails the claim on causation. Next slide, please. And in Mills and Oxford University's trust, there's a permanent neurological injury suffered as a result of a hemorrhage during brain surgery. The brain surgery was performed using a new surgical technique. It wasn't done negligently, but the surgeon never advised the patient that he was doing a new surgical technique and there was an alternative available. And there it was found that the claimant would have undergone the alternative surgery using standard technique if given the option, and there was a nexus between the difference in techniques causing the complications that in fact arose because it was harder to control hemorrhaging using the new technique, and therefore there's a very clear factual but-for causation established, and the court there is happy to find causation. Next slide, please. And in Malik and St George's University Hospitals NHS Foundation Trust, again, there's a pre-breach issue of a patient having emergency spinal surgery. There's no negligence there, but after the surgery, he reports numbness in his leg, and his surgeon says, well, you should have some more revision decompression surgery, and Mr. Malik very sadly ends up as a paraplegic. So it was when the surgery failed, the case was, well, rather than giving him decompression surgery, you should have given him other alternatives, less invasive alternatives like injections. But again, the court kills the case on causation and says, well, if he'd been offered an injection, he wouldn't have gone for it. He always would have had the operation. And therefore, in any event, he would have been left in the state that he's in now. So causation fails. So you see, again, we move away from Chester more and more and more. Next slide, please. And Negus and Guy's and St Thomas's Foundation Trust very recently is a patient prosthesis mismatch that leads to the need to redo some surgery with a larger valve in the aorta, and we have unfortunately again death from heart failure during the post-operative recovery. And effectively the case was he should have been warned earlier the first time the surgery was done to have the aortic root enlargement procedure. Next slide, please. And we end up with the fact that Mrs. Justice Eady concludes actually there was a limited duty to warn that he might need to have this valve replacement operation with an ARE, but causation not made out because the patient again would have done exactly what the patient did in any event, and that a causation fails. Next slide, please. And so, in summary, I spent the first part of this talk talking about Chester and Absher and how it's quite an interesting nexus with Montgomery, and they seem to build on each other. But actually, when we look at Duce, we seem to find Chester actually seems to be problematic. in relation to causation. It has unclear policy grounds. It only applies in exceptional circumstances. And you can see exactly where we're going now with causation. We are in straightforward but-for causation being necessary. We can't have freestanding damages for a breach of autonomy. And the issue is very much a factual one. Would the patient have consented to the alternative treatment if they'd been informed of the same? And really on causation now, you need to show that the claimant would not have had the treatment if properly informed, or as a minimum, the claimant would have deferred the treatment. And then you're into arguments about that. But that's where we are. And I'm going to hand over to Ella now to look at some practical tips.
Thanks, John. So yes, having dealt with the law, how do we bring and how do we defend these claims? So one of the issues that comes up quite often is dealing with disputed accounts of the consenting process. So in some way, you've got a claimant saying, I wasn't told this, and a doctor saying, no, I'm sure I would have told the patient that. One of the first and most important things to do is to take early statements. It is well known and well recognised by the courts that people's recollection fades over time, and that worse than that, people honestly, but mistakenly, every time they access a memory, tend to rewrite it slightly. So the earlier you take those statements, the more value they will have. Even if later on you're going to have to then do a fuller statement for litigation purposes, get something written down and with a statement of truth early as to what was discussed. Obviously, if the clinician really isn't able to evidence through their notes what they said, they can rely on their usual practice. It's not the best evidence though. And it's important when you're asking your clinician, if you're acting for the defendant, questions about that you ask them about their usual practice at the time. So they may have developed their usual practice as a result of this incident. They may be now particularly aware of the risk that they didn't warn about before. They may be a more senior doctor, they may have other experience. So the question is, what was their practice at that time? And with all parties, be aware of the impact of hindsight. Obviously, these cases usually come about in the context of some sort of disastrous consequence, which is now looming large in the minds of all relevant witnesses. And they will no doubt be, again, quite honestly, but mistakenly trying to persuade themselves of what they did or didn't say as a result of that knowledge that they have. So be conscious of that. You need to have a look at the notes themselves. So I've said, look at whether or not they're fairly full. So if you have a clinician who has written in their, say, manuscript clinic notes, a list of 5 or 6 risks that they identified for the patient, but not the one that is the subject of the claim, I would find that potentially a bit suspicious, because if they've written all of the others, you would have expected they would have written down all the risks that they warned about. If, however, they just have a note that says discuss risks and benefits for the patient, which I have to say, unfortunately, is what I see more commonly, then there is scope for both parties to argue about what those risks and benefits that were discussed were. And I would also recommend comparing clinic notes and correspondence. And I would suggest that manuscript clinic notes are likely to be of greater significance and weight than correspondence, because by its nature, the letter that a clinician sends to a GP, perhaps after a clinic, is usually sent later that day, if not even later. Again, the clinician might have seen very many patients in that time. They're now trying to remember what they discussed. Those letters may be of a fairly standard form, dealing with the conversations they usually have. I would suggest those are less significant than clinic notes. If you've got a clinic note written while the patient was in the room saying, I told the patient of this risk, that I think is going to be your better evidence. So then what do we do with our experts? And we've had one question as John was talking that I didn't answer and chose to answer live because it's really dealt with on this slide. But that was a question from Paul Sankey, who asks, what questions should we be asking medical experts to address, and what questions are outside medical expertise? There were judgments where the courts appearing to be consider expert evidence on issues which Montgomery was trying to keep away from the experts, such as what risks do the doctors normally advise of. And I completely agree with the premise of that question. Although we've had a very clear exposition of the law from our first 2 speakers, I have to say, in practice, I don't always see those tests being applied throughout medical reports. And we obviously take responsibility of that as practitioners. We have to ask the right questions of our experts, and we have to pull them up when we don't think they've covered the right tests. So they need to understand their role. which as a rule is much more limited where the governing test is Montgomery than Bolam. We've heard in respect to the case of, I'm going to call it Deuce, although I think between the three of us we might have come up with three pronunciations of that case, I don't know. But there is a two-part test that, again, when you simply read that case, seems very easy to apply, but I have to say I don't think is always being applied in the medical reports that I see. So it is not enough when you see from claimants often reports that say no reasonable body of doctors would fail to advise about this particular risk. That's potentially useful evidence, but it's not actually the test that they're supposed to be addressing. And worse is defendant reports that will seek to defend a case saying, there's a reasonable body of doctors that usually doesn't advise about these risks. That doesn't cut it anymore. Bolam does not apply. And that's why, at least on breach, these cases are quite difficult to defend. All of that said, evidence of common practice, I think, can still be useful. So to take the example of that claimant report, if they are saying that everybody warns about these risks, no reasonable clinician doesn't, that is going to suggest that the Montgomery test is also satisfied. Similarly, I've been involved in a case where our defendant expert has said, I have gone and asked all of my clients about this risk, and it is so rare that all of these consultant colleagues that I have never come across it. None of us knew about this. This is the first time any of us have ever heard of it happening. And therefore, we understand why, effectively, it wasn't warned about by the doctor. And really, you have to take yourself back to that two-part test. So it is fine in that scenario for my expert to say, it is reasonable for a doctor not to be aware of this risk. This is one that is not commonly known. But what is not reasonable is that, but what the expert does not then comment on is the warnings that should be given. That's a finding of fact for the court, not for the experts these days. And worse, in my view, is when you see experts expressing opinions on causation that are properly matter to the court. And it does matter that you get your experts to get this right, because judges don't like feeling that their role has been usurped. They are ultimately the finders of fact, not the experts. So again, you will see reports sometimes where an expert will say, if the claimant had been warned of this particular risk, on the balance of probabilities, they would not have gone ahead with the surgery. That is not for the expert. That is a finding of fact for the court. That's not to say that your expert has no role in causation, because again, to come back to Paul's question, the question you should be asking of your expert is, okay, if the claimant had been properly warned, what would they have been told? What risks would they have been told about in terms of alternative treatments? What benefits of alternative treatments? You want the fullest detail possible from your expert as to exactly what was involved in alternative treatments and exactly what the information that should have been given is, so that the court is then well equipped to make their own finding about what on the balance of probabilities the claimant would have done. And then this slide is about proving a counterfactual. So again, the issue in most of these cases, as I say, that they're difficult to defend on breach a lot of the time, but where claimants find themselves in difficulty is proving what they would have done with different advice. So I've covered really already that first bullet point. You need to make sure your experts have given you precise evidence about exactly what the claimant should have been told in terms of the risks and benefits of the proposed and any alternative treatments. A tip I would give is to look at the risks that the claimant did consent to. And in light of those, is it likely that the information about the risk which materialised would have changed their mind? So, for example, I've seen cases where claimants have consented in surgical cases to really quite serious risks. Again, nerve damage, chronic pain, bladder injuries, and then a bowel injury has materialised, and they said, well, if I'd known about that risk, I wouldn't have gone ahead with the treatment. And I think you have to be quite sceptical of those sorts of claims, because if a claimant was really willing to put themselves through all of those other extremely serious risks, is this one that they weren't told about? Would that have been the straw that broke the camel's back? Or would they have agreed to that just like they did all of the others? And similarly, consider the benefits of the proposed treatment and what doing nothing would entail. But was there any realistic alternative? And I had a very practical demonstration of this personally recently. I had to go see a dentist and have a wisdom tooth extracted. and was warned appropriately that there was a risk of nerve damage. And like I suspect many people on this call, I don't think I am the only one, doing this job and being a clinical negligence lawyer, I have to say I do sometimes have a tendency to expect and fear the worst when warned about these risks. So I asked further questions about this risk of nerve injury and was concerned. But ultimately, the dentist said to me, if you do not go ahead with this, that tooth will cause you problems. You will get decay, you will have issues down the line. And I can say that is absolutely certain. The benefits of removing it far outweigh the risks. And ultimately, despite still sitting here with my clinical negligence hat on, fearing the worst, being told that the alternative was that there was an absolute certainty of difficulties, I went ahead with the treatment. And I'm happy to say don't appear to have suffered any nerve injury. But those are the sorts of questions, again, that you need to consider. What would the claimant be left in, for example, ongoing chronic pain from the condition that they're being treated for if they didn't undergo this surgery? And if that's the case, how likely is it that they would have ever refused? And then, perhaps not properly headed materiality, but you need to consider what you know about your specific claimant when you're assessing what they might have done with different information. So I've given the example there about people who are young and have no children being more likely to be put off by risks of fertility than older people with complete families. But you really need in all your cases to do a trawl of all of the records and see what you can find out about the claimant. And I say that whichever party you're acting for. What can you see about them that might, again, evidence one way or the other what they would have done? So I had a case where the claimant had effectively turned up at A&E, plonked herself down and said, I am not leaving until I'm treated, and had been absolutely insistent about receiving treatment. I thought that was useful evidence, and then considering whether or not she would have later refused treatment if advised about different risks. So that's the sort of careful eye that you need to have for your evidence. And then dealing with reasonable alternatives. Again, we know what the law says about that. The alternative has to be one that is reasonable. It can't be, for example, so novel a treatment that nobody was offering it. But even if your expert has said, yes, that's a reasonable alternative treatment, consider things like, was it available as a matter of fact? But was it available at the same hospital? If the claimant had wanted to undergo that treatment, would they have had to wait? And would they have been willing to wait? I've had cases where a surgeon has said, well, yes, that was a reasonable alternative treatment that the claimant is now relying upon in their claim, but it's not one that I was trained in giving. Again, quite reasonably. There were people in the country that could do it, but I wasn't one of them. So if she'd wanted to access that treatment, she'd have had to have gone and found another opinion. Now, and again, you might ask whether or not the claimant would choose to do that. And I think really we've covered already that alternative must be a reasonable one. So that is, again, a place where your expert has a role. So I don't want my answer to Paul's question to come across as saying that there's no role for experts in these cases, but they are more limited than they used to be. So I think we've managed to bring that to a close at exactly 1 o'clock, and we've kept to our proposed timings. I don't see any other questions in the Q&A, but I'm certainly happy to stay on the line for just a few more minutes. If anybody does have any questions that they would like to add into the Q&A box, we'll deal with those if we can. And of course, our email's at the bottom of that last slide. If, as always happens to me, you get out of this webinar and you suddenly think of a burning question that you wish you'd asked, then please do feel free to contact us. This webinar will also, it's been recorded and will be shared on our YouTube channel, so you can come back to it. But I don't see any more questions coming through. So just leaves me to say thank you very much, everybody, for your attention and for joining us on this, our very first Decanar.